Good afternoon. Thank you very much to everyone that's taken time out to join us today for our webinar on the skilled worker route, the new route that has just opened up a couple of days ago as part of the UK's post-Brexit immigration system. Shiraz and Nina will be taking you through the details of the new system, the guidance, and other relevant matters as best they can, because the route has only opened up 2 days ago. We have very little experience as to how the route is going to operate in practice. And there is, in our experience, usually quite a gap between what is in writing and what the Secretary of State's practice is. And of course, the guidance has also just come out, and lots of it has come out. And getting on top of all of that is not straightforward, and there are lots of gaps in the guidance, and there have been questions put to the Home Office in relation to certain issues that don't seem to be covered fully in the guidance or the rules, we are waiting for the Home Office to revert to us in relation to that. So we'll do our best to take you through what we know at the moment, and we will no doubt be doing some follow-up webinars as more information comes to light, more guidance comes to light, and also to take sponsors or prospective sponsors through the process of applying to become a sponsor, because a lot of people, I think, will need to now become sponsors as they realise that they cannot recruit from the EU in the way that they used to before. There will be a question and answer session at the end of the webinar. In the usual way, if you could put up questions in the chat function, and we will do our best to answer those questions at the end of the webinar. And if we can't get through all of them, we will do our best to get back to you directly by email. The slides will be available for everybody after the webinar, and we are also recording the webinar, and we will be putting that up and sending a link to everybody that is registered in case you want to watch us go through it all over again. I'm sure you will not, but you never know. You might want to review some parts of it. If I can also just say at the outset, we are obviously available if anybody needs any assistance with the skilled worker route or any other aspect of the immigration system. I think we have a lot of solicitors on the webinar today. You can instruct our members in the usual way, and we have some lay people here as well, and we're able to take instructions on a public access basis as well. Our contact details are on the slides. You have our email addresses as well. So if you do have any queries, please do feel free to get in touch. Could I have the next slide, please? So this is my only slide. I wanted to do this one because I like it. It's a bit tongue-in-cheek, because as well as the new immigration rules being a response to the UK's exit from the European Union and introducing a new route that covers both EU nationals and non-EU nationals, one of the stated aims of these rules is a simplification of the rules. And this is, on this slide, a quote from a March 2020 document from the Home Minister in response to a Law Commission report, a consultation, and there has, many of you will be aware, been recent criticism from the Court of Appeal of the complexity of the immigration rules. You know, a long line of previous cases as well have criticised the complexity of the rules. One of the aims is to simplify the rules, but I think you will see, as Shiraz and Nina take you through the rules, that I really cannot see how that has been achieved. The new rules are flexible, but very complex, very tricky, and I'm not looking forward personally to going through them and seeing how they operate, because it's going to take a lot of time, a lot of dedication to get on top of everything so that you can properly make applications that don't fall foul of various technicalities which are still there in the rules. So I will hand over to, I think Shiraz is going to take you through the first part of the presentation.
Hello, everyone, and thank you very much for joining us today for this webinar. As Zainul has already addressed, there's a lot of guidance that has been published specifically within the last 3 weeks. I think we're looking at somewhere over 300 pages at this point of guidance that has been specifically provided for all types of the new immigration routes coming up, but particularly for the skilled worker. There's been caseworker guidance that has been provided for just on the 1st of December, the same date that the rules came into force. One would have expected or hoped that if this is going to simplify things, we maybe could have had this guidance a little bit earlier, especially given that the statement of changes to the immigration rule was provided in advance on the 22nd of October. But we can only hope for simplification in the way that we would like, and in a way that would be more pragmatic for our own practices. But going forward in terms of today's agenda, we'll look at the background because it's important to contrast where we were to where we're going. Thereafter, we'll look at current Tier 2 general migrants and how the skilled worker route affects them, specifically with regards to where they are right now and what is happening after the 1st of December 2020. But we've had a lot of inquiries about what happens with settlement. And so I thought it'd be very important for those that are joining us today and for practitioners to also understand what settlement options are available to them. And thereafter, we'll jump straight into the skilled worker route rules and the guidance. Our specific focus will be on the 1st of December 2020 guidance. And the reason why we've chosen this is because this is what the caseworkers will be applying when making decisions on applications. So it's very important for applicants, sponsors, and anyone that is involved in this field in general to understand what considerations will be applied to applications in the future. We'll also look into making a valid application under the skilled worker route. And towards the end of the webinar, we'll lightly touch on the new sponsor guidance. It's just not been possible for us to digest over 300 pages of material and then consolidate that into a 1-hour webinar. So we've focused on this webinar for the skilled worker route, and in due course, we'll be addressing in full the new sponsor guidance. And thereafter, we'll actually look into the future. And when I say the future, we're in correspondence with the Home Office. We've put questions to them about some of the concerns we have about the system, and we've received some interesting answers, and we expect to also receive some very interesting answers in the future. But what I would say from the outset is brace yourself, because these rules are complicated, far from simple, especially when it comes down to complex mathematics that is required of sponsors. Accountants most definitely are going to be needed, which is going to be an added expense. So please be aware of this. And as I say, brace yourself. If I could have the next slide, please. Right, now jumping into the background. So in preparation for leaving the EU on the 1st of January 2021, the immigration routes have now been implemented by the Home Office in terms of the new skilled worker route. As I've already mentioned, we had the statement of changes, which was published on the 22nd of October 2020, and the raft of new guidance in November and December. The one thing I actually want to point out here is the Home Office are looking at this as I say, simple, effective, and a flexible system. Although, as far as we have seen, and as far as I've seen in terms of the guidance, there clearly are teething problems that will be faced by sponsors and applicants, and especially with the sponsor management system and how that is compatible with the current rules, especially when it comes down to Tier 2 general migrants currently here in the UK, whether they have been assigned or unassigned at this moment in time. And I will address this in short, in due course. But also, one thing that needs to be considered as well is the new concept of tradable points. My colleague Nina will be looking at this in more depth, but this is seen as the flexibility. So you have certain mandatory requirements which all applicants have to meet, and then you come to the flexibility, which is the tradable points under the points-based system. And this is really where it starts to get complicated. But with Brexit and the end of free movement for EEA nationals on 31st of December 2020, the points-based system will very soon be the only option for foreign nationals wanting to move to the UK to work. And so it's very important that we all are aware of what exactly is going on. And so with the background now having been set out, I actually want to start to look into the guidance and what is available for sponsors and applicants to read, and as well as practitioners, I should say. Can I have the next slide, please? Guidance, guidance, and more guidance. The Home Office has published extensive guidance to supplement the skilled worker route since October. We've provided a breakdown of some of the guidance that sponsors should be aware of, firstly, and the dates in which they were published. Obviously, this will be subject to, I'm sure, many more revisions of the guidance, as any practitioner or those involved with the Home Office will already be aware. The manuals for the sponsor management system have also been updated in some regard, and these will be looked at in the future. But our focus will be on what we have under bullet point 2, under workers and temporary workers, which is skilled worker, and the guidance that caseworkers are applying to the applications, specifically with regards to those looking to enter newly under the skilled worker route from outside the UK, those looking to remain in the UK, and lastly, those who are looking to settle in the UK under the skilled worker route. If I could please have the next slide, please. Right, Tier 2 General. This has been a reoccurring question. Most of our questions have been focused on this. What is going to happen? Well, currently, I can assure you that currently Tier 2 General Migrants leave will still be valid after the 1st of December 2020. So if your leave extends beyond the 1st of December 2020 as a Tier 2 General Migrant, you're fine. But when it comes to extending that leave, or if you're seeking indefinite leave to remain, then those applications will be considered under the skilled worker rules. And that's something that I will address in due course. The first element I actually want to address for Tier 2 General, however, is indefinite leave to remain applications. Again, there's been a lot of interest in this. But one point I want to just highlight from the outset is there are routes that are just not applicable and cannot enter this route. You can't switch into it. And those are mainly short-term visas. And I thought it was important just to flag that up initially, because a lot of people wanted to know whether visitors, for example, could come into the skilled worker route. And unfortunately, the answer is no. Could I have the next slide, please? Right, so what I've tried to do for you here is condense down the settlement requirements for you. You'll have to forgive me because I've tried to be as thorough as I can be. I've provided a breakdown there, and I will tell you about how each one works and what requirements need to be met. So first of all, under Appendix Skilled Worker, it provides that a person who held Tier 2 General Migrant status before the 1st of December 2020 falls within the definition of a skilled worker. Now, this is very important because if you're seeking to apply for indefinite leave to remain, one of the requirements is that you are within a category of persons. We have a category of leave. One of those is being a skilled worker. So therefore, Tier 2 General Migrants are able to apply for indefinite leave to remain. However, there are certain requirements that have to be met. The first is validity. This is fairly straightforward stuff for any practitioner, anyone who's already been involved in making applications to the Home Office. I've got notes, so if you want these slides, please feel free to ask for them. And they provide fully and set out everything here that I'll be discussing. But just to let you know, what is a valid requirement? Well, firstly, the correct application form has to be used. It's an online application form and it's called SET-O, O for Oscar. The application fee must be paid. You should have provided your biometrics, and you should also provide enough evidence of your identity, such as passport or travel documents, to satisfactorily evidence your identity and nationality. So these are fairly straightforward requirements to meet, and hopefully many applicants or all applicants will be able to meet these. However, when it comes down to suitability, again, this is fairly straightforward and is not uncommon with certain features of other indefinite leave to remain applications and requirements. First of all, you shouldn't fall for refusal under what's called general grounds of refusal. You should not be in breach of UK immigration laws, but certain exceptions apply to disregard overstaying. That in of itself is a current issue that is still being litigated about. There's a lot of confusion about that as we speak, so I need not or shall not go into that. But lastly, also, you shouldn't be here on immigration bail. Apart from that, as long as you satisfy that, you're fine. You've met the suitability requirements for indefinite leave to remain. Eligibility, however, is a chasm, and I will try and break it down for you as best as I can. First of all, you must have spent a continuous period of 5 years in the UK, very similar to Tier 2 General, nothing uncommon about that, and nothing striking either. The 5 years must consist of time with permission on any of or any combination of skilled worker or other categories also recognized, such as, for example, global talent or innovator, etc. So effectively, you should have in part somewhere the skilled worker route. Continuous residence, again, a feature of other indefinite leave to remain applications. Practitioners and maybe individuals will already be aware of this, but there is a dedicated appendix now. Great, more appendixes for us to read and more guidance to come. And there's also guidance on this as well, which I've gone through, and I've consolidated this in my notes. But just to let you know, you have to have a continuous period in the UK of 5 years. And it must be spent in the UK, and it must be spent in employment. So that's a few things that are very important there. In terms of another requirement for continuous residence is their absences. And again, nothing uncommon or striking with this. I'm sure to many I'll be preaching to the choir. Caseworkers will examine how many days absent from the UK the applicant has accrued, or absent, sorry, they have accrued from outside of the UK. 180 days is allowable absence, as they say, in any consecutive 12-month period. Only full days will be taken into account. And therefore, if an applicant had a single absence of less than 24 hours during a 12-month period, that absence simply wouldn't count. As far as the guidance says, whether that is construed in a different way in practice and how it's applied, remains to be seen, and where the cutoff point for hours, and we're talking about minutiae such as that, can be important for someone who has actually met 180 days in full, and maybe that extra day will take them over the 180-day allowance. They must also provide an explanation for their absences, and they must provide evidence. This is a common feature throughout the casework guidance. They are hot on making sure that applications are satisfied. It seems like there seems to be a bit more flexibility than I've seen in the past, but it is concerning in some senses of how they go about applying their request for information. And I will address that shortly, because that's a whole issue in of itself, and I've dedicated a whole slide to that. But there are circumstances where, if you have been absent from the UK for a short period of time, i.e. less than 30 working days, they will not need any explanation from you. And they might actually go about exercising discretion and consider the application without any further evidence. However, I would say it's always important to provide the explanation, no matter how short or how long the absence is. And why submit evidence? Well, it's pretty much because the Secretary of State or the Home Office wants to consider this against your current work and whether it is actually accords with your work in the UK. And the guidance says, verbatim, that the absence must be consistent with or connected to the applicant's sponsored or permitted employment or permitted economic activity being carried out in the UK. So for example, business trips or short secondments or paid annual leave would be an allowable absence. However, it's important for both the applicant and the sponsors, in my view, to ensure that if you have paid holiday, that you are within that entitlement, to ensure that you have a consistent or permitted employment. So to ensure that the absence is consistent with your employment, and therefore ensure that there's no issues raised by the Home Office. What is very interesting to see is also that short visits outside the UK on weekends or other non-working days are considered to be consistent with your employment, but they will still count towards the 180 days. So those in short, if I can just review that, in terms of being eligible, you should have demonstrated that you've been in the UK for a continuous period of 5 years. You have to demonstrate that it's in the UK. Firstly, please make sure that I want to highlight that. It's very important because work in the Channel Islands isn't covered. Absences are looked at, and evidence is very important to back up any absences that you have. And also, I've addressed you as to why evidence is important. There are two further requirements that need to be met for indefinite leave to remain. And I've addressed that on the slide. The first one is sponsorship and salary. So eligibility requires the sponsor to still hold a skilled worker license, and the sponsor must confirm that they require the applicant to work for them for the foreseeable future, and the applicant will be paid the minimum salary for the foreseeable future. Now, a sponsor doesn't need to assign a certificate of sponsorship for the purposes of an indefinite leave to remain application. And if they are providing a letter to confirm that the applicant is required for work and they will be working for the foreseeable future and pay the minimum salary, well, it seems to be quite flexible in that they've asked for an email or a letter to be sufficient. They've said that an email or a letter from the sponsor is entirely sufficient. However, they will verify with the sponsor. Now, my experience has been that when the Home Office is seeking to verify anything, the most they'll do perhaps is maybe give a call. If that call is missed, or if an email perhaps is sent inadvertently goes into your junk mail, that could have significant consequences for the application itself. And a refusal, as we all are aware, can cause some issues as well. So that's sponsorship. In terms of salary, from the salary must be at least £20,480 per year, or at least the going rate for the job, where the most recent permission was a job on the shortage occupational list. If it's not on the shortage occupational list, then it must be at least 25,600 per year and at least the going rate for the job. I know I've introduced some new terminology in their going rate, but please bear with us. We will demonstrate to you what the going rate is and how that works. Now, particularly for those with tier 2, right, there has been some very interesting allowances. If the date of the application, you can see it under sponsorship and salary, the second bullet point, if the application to extend or is made before the 1st of December 2026, you will still need to meet what we will address soon as the salary requirements, but your salary may also include allowances, such as, and that is contrast against allowances, for example, what would be for the same sort of job in London, for example. So that's very interesting to see that allowances can be taken into account. And if the application, as you can see on the third bullet point, if the application to extend is before the 24th of May 2023 for a tier 2 migrant, the minimum salary you will need to be paid is fixed at what the Home Office calls the lower rate, and you will need to be paid at least 20,800 per year unless the going rate for your job is higher. And I understand that's fairly complicated. I've tried to sort of explain it in the best way possible. But again, there's a raft of guidance here, which unfortunately doesn't help. But the last 2 points is knowledge of life in the UK is still a requirement, and English language requirement is also there. But if you've met the English language requirement previously, it will be taken as read that you have met it this time as well. So that is the general overview for settlement as a tier 2 migrant under the skilled worker route. If I can have the next slide, please. Now, the route itself, what is changing? Well, we have new terminology, as you've heard me all along. We don't have tier systems anymore. We have, for example, the skilled worker route. Immigration rules, we have new ones that have come into force. And for EA nationals, they will now fall under immigration rules from the 1st of January 2021. We have skill level reductions. So for example, the educational level requirement has been reduced. English language level has been reduced. Minimum skill levels are now introduced. And minimum salary has dropped down from 35,800 to 25,600. One thing I wanted to point out, and I addressed this earlier, was switching in country. There are more options available for applicants. However, switching is not available for short-term visas. And I'll outline those just very shortly. We've got visitors, short-term students, parent of a child student, seasonal workers, domestic work in a private household, and just generally outside the immigration rules, people who are here outside of the immigration rules leave. And so those are the general sort of what is changing. And elements being removed completely, well, we no longer have a 6-year cap in a route. You no longer have cooling off periods. Restrictions on ownership in shares is gone, and the cap on new workers from overseas is suspended, not removed, important to note, but this could be reintroduced in the future. If I could please have the next slide, please. Right, okay, so what are the features of the skilled worker route? Well, the new system of rules and guidance is meant, as we already addressed, to simplify the requirements. It's meant to be more streamlined, making best use of technology. And when we've spoken to the Home Office specifically about this, they are keen to bring in a system in which fast and fluid communication between sponsors, applicants, and themselves is facilitated. The issue we have at the moment is it doesn't seem to be fast and fluid, but we're hoping that in due course it will be. And some of the innovations that we have heard about when speaking to them has actually been very useful. For example, sending evidence to them electronically. However, issues that I've identified seem to be that when you're assessing whether a document is genuine, usually the Home Office require that document to be provided to them. However, if it's provided electronically, the question remains, how are they looking to do that? And that's something that the guidance isn't all too clear about, except for referring to other versions of guidance which don't seem to address the issue specifically. But so this is something that is clearly a development, and unfortunately doesn't seem to have been thought out all that well at this point. But what is staying the same? Well, the sponsorship license remains essential. Sponsors need individual certificates of sponsorship per worker. It's assessed on a case-by-case basis with individuals in mind, and we will address exactly what they'll be looking to assess. We've got skilled occupational codes, very similar to what we've had. It's appendix skilled occupation, very similar to how the Tier 2 general migrant system worked, and minimum salary requirement, as well as a 5-year route to settlement, which includes family members such as partners and dependent children. So these are some sort of common features that I've identified. Could I have the next slide, please? Right, okay, so you want to make your application. What is it that you need to demonstrate? Well, firstly, validity. You need to demonstrate that it's a valid application. And this is something that is very easily satisfied, in my opinion. It's very simple. I've provided in the next slide a breakdown. If we could just go to the next slide, it'd probably be easier for everybody to look at the validity requirements. So as you can see, sorry, I think it's the slide previous. There we are. Yeah, that's the one. So as you can see here, I've set out the fees for an application, and that is what is required for a valid application. You need to make sure that those fees are paid. If you don't pay the right fee, it will be rejected as invalid, not rejected on the substantial merits of the application, but simply that you haven't met a procedural requirement. You also need to make sure that you've provided your biometrics and identity documents. You have to have a certificate of sponsorship. Now, this is, as everyone will most likely be aware, a virtual document which is assigned by the sponsor on the sponsor management system, and there will be a reference number on the certificate of sponsorship. There is a minimum age requirement in this one. If you're coming to skilled worker, you cannot be below the age of 18 on the date of application, very important. And switching requirement, I've already covered that. If we can just go back to the previous slide now, I will now delve into suitability. Suitability requirements, now the applicant just needs to demonstrate as before, as I've already discussed, very similar to ILR requirements. Firstly, general grounds of refusal don't apply. Secondly, that they're not in breach of immigration laws. I've put in brackets with some exception to disregarding periods of overstaying. And lastly, that they're not an immigration bail. Apart from that, seem to be fine. The guidance recognizes nothing beyond that. And lastly, then eligibility. The main requirements here really for entry clearance is that you must be applying under the skilled worker route and looking to obtain a skilled worker visa. You should not be in the UK if it's for entry clearance purposes. Again, for entry clearance purposes, tuberculosis certificate should be provided. It's a medical certificate for those who are already not aware. It's very similar to what was required before under the relevant appendix. Nothing has changed. But effectively, the certificate should confirm that the person has undergone a screening for active pulmonary tuberculosis and that it is not present in them at that moment in time. Apart from that, that's fine. You need to demonstrate that you have disclose any criminal records, if any, for consideration. And lastly, that you meet the financial requirements. And we've addressed that already. As long as you've done that, well, you're on your way. But I want to now look into specifically how a suitable and illegible application will look. So if I can ask for the next slide. This is the one that I've addressed. So here we are. So what I've done for everybody is I've provided a list here, a nice table for everyone. What you can see is you've got the main applicants who apply for entry clearance and permission to stay, and you've got the relevant rules under appendix skilled worker at the moment, which hopefully will be the skilled worker route in due course under immigration rules. But you've got the relevant rules that apply for validity. suitability, and eligibility. And that is the same for main applicants for applying for settlement. It's the same for dependents applying for entry clearance and permission to stay, and the same for dependents applying for settlement as well. I just thought this would be very useful. It helps to put everything really into context, I think. And it's also easier for people looking to navigate these rules to have them in one place just to sort of traverse and get through. If I could have the next slide, please. Now, one feature I thought was very, very interesting was the constant reference to requesting information. It is littered everywhere in the caseworker guidance. And I think this is pretty much because the Tier 2 General route, there are elements of what existed in the Tier 2 General route that have now been updated. Now, and there are further requirements that a Tier 2 General migrant would have to meet if they're applying under the skilled worker route, or if they haven't been assigned, if they fall in this sort of lacuna of time where it's between a transition. Well, they've said, well, look, we're happy to be flexible. We will make requests for information. However, how they approach the assessment in order to make that request is very interesting. They say that they will take a fair and proportionate approach to the assessment of evidence. Any of the lawyers here on this webinar are going to realize straight away that this is quite a litigious sort of way to frame something. It's not exactly clear, and it's really down to the decision maker's discretion as to what is fair and proportionate. And I thought it was worthwhile pointing that out. One thing that they've said, and they'll assess whether they need to actually make a request for information, is whether the applicant or the sponsor has made a clear error or omission. And again, the focus is clear. What is clear? You know, if somebody has a sequence of documents and they've failed to submit one document, is it clear that there was just an omission there? That's not really that clear in the guidance, unfortunately. However, what they have done, which I thought was very interesting, is for those that have already applied for sponsorship, they have said that they will request information from sponsors of their PAYE reference numbers, because this wasn't required previously. From what I understand in the guidance, they've acknowledged that it wasn't required previously. So sponsors should look out for any requests coming through from the Home Office. And there is a case that I wanted to point out very recently. It's Tapadar. Now, in that case, it's very recently came, I think it's within the last 2 weeks, the Court of Appeal decided that the Home Office's failure to notify the individual applicant that she had requested further evidence from the applicant's sponsor when deciding the application was not procedurally unfair. Now, this is really important, because if a request is made to the sponsor, but that request for some reason isn't dealt with in time, or is no one sees it, well, what's going to happen then? Well, the application, unfortunately, seems like it will just be refused unfortunately, because information hasn't been provided. However, I would say that there is a glimmer of hope, because this case, the facts are very specific. The request for information in this case was for information that only the sponsor reasonably would hold. So for example, it was whether the account manager was needed and what duties they would do. And they asked for the sponsor's bank accounts and the staff list and company accounts and tax details. So with those facts in mind, one can understand why the judges led to their conclusion that actually there was no need for the applicant to be informed, even if it was just simply so that the applicant could keep in touch. But one thing I would say is it's never good to just hope that everything goes well. I would suggest that based on this, we have applicants and sponsors that keep in constant contact with one another to ensure that any requirements or any requests for information from the Home Office are met quickly, to ensure that applications are processed quickly. And also, I would also say that this is a reminder that trying to fix a points-based system application is a dangerous task for applicants. And they are in a much superior position, in my opinion, if they just follow the standard procedure when making their application for leave. Otherwise, if they attempt to be excessively creative afterwards, it creates a whole load of issues, and especially in the sense of litigation. Another feature that I thought was very interesting is verifying documents. I've already addressed this with respect to electronic submission of evidence that people want to rely upon. It's very interesting to see that this is the way that things are going now, but unfortunately, it's not all too clear how these documents will be assessed by the Home Office. And lastly, just please make sure that any documents you are sending to the Home Office, they are translated, because otherwise they will be rejected on that basis. Now, if I could please have the next slide, please. Okay, so I've already taken you through validity requirements. I've taken you through suitability requirements, but now is the time for the complication, eligibility. It's split into two. I will be addressing the mandatory points that people need to accrue. It's 50, as you can see on the table that I've provided, 20 for sponsorship, 20 for a job at an appropriate skill level, and 10 for English language skills at least level B1. However, the complication really arises with tradable points. And because of that, I've relied on Nina to take us through that. But before we do that, I just want to walk you through exactly what these elements are and how the Secretary of State wants you to satisfy them when we refer to her guidance, not just the rules, but the guidance. So sponsorship, in order to get those 20 points, first of all, you have to have a certificate of sponsorship and it has to be valid. It should confirm the applicant's name. It should confirm that they are being sponsored as a skilled worker. It should provide details of the job and the salary the sponsor is offering them, and the PAYE details if HM Revenue and Custom requires income tax and national insurance to be provided by the sponsor. Please bear that in mind, sponsors, very, very important. If it's for entry clearance, slightly different. The costs must be defined, which means that the sponsor must ask, or at least be asked for a specific job and salary, and not just, it can't just be assigned from their general allocation specifically for this job. It should include a start date, it should, as stated by the sponsor, and the start date should be no more than 3 months after the date of the application. These are important features that I thought that I'd point out. But this is something that everyone should be aware of, because I think that this is where, although the Home Office is saying that this is flexible and it's going to be a new way of conducting application consideration, there is something called the genuine vacancy element. If you can see, it's bullet point 1, and I've highlighted that for you. My notes are quite lengthy on this, so please ask for the slides if you want. I'm sure they'll be sent out anyway. But genuine vacancy. The guidance says that the caseworker must not award points for sponsorship if you have reasonable grounds to believe the job the applicant is being sponsored for does not exist, number 1, is a sham. For example, the job exists, but the applicant just won't be doing that job. And lastly, has been created mainly so the applicant can apply for permission to come to the UK or to continue to stay. So a contrived situation effectively is what they're trying to go for here. They will then assess this against any information that they already have. However, they may request information. And the ramifications where there's a suspicion are actually quite extreme. First of all, they say that they may interview the applicant, not that they must, but they may interview the applicant and give them the chance to respond. Now, I would say that if somebody's applying for a vacancy and they've provided relevant information, if there is any suspicion, you should interview them and give them the opportunity to respond. But at the moment, it's a may, so it's entirely discretionary on them. And what can actually result in this is if after they've interviewed you, or just in general, if they have a suspicion, it may lead them to a compliance visit to the sponsor. So sponsors need to be very aware of what information is contained within the application itself, because if their concerns are maintained throughout the application process and are leading up to their decision, then it could lead to the sponsor license being revoked, and that is explicitly referenced in the guidance. So please bear that in mind. So that is sponsorship. As long as the cost the cost requirements, valid, etc. are met, you'll get the 20 points. How do you get the 20 points for a job at the appropriate skill level? Well, it should be in an eligible and appropriate occupation code, and they've provided appendix skilled occupations. Wonderful, more appendix. And once you start looking at the raft of immigration rules is actually quite dizzying, unfortunately. So that's the first thing. What they'll also look at is whether the job role has been exaggerated or is incorrect when compared to the occupation code that's being applied for. Now, this is something that isn't, as far as I have seen, featured anywhere else. It's something that I think is actually quite new. So if they feel that the sponsor has exaggerated the role or that the occupation just doesn't fit within the role based on its description, they can take actually quite serious steps after this. But firstly, there are two factors that I want you to be aware of. The first is that they will assess the job description against whether it's just a general description that has been provided by many other businesses and isn't tailored specifically for this role. And secondly, whether the sector that the applicant will be working within is what's called a high-risk sector. And secondly, they will actually look at the applicant themselves and whether they have been refused previously on the same grounds. They'll also look at the sponsor's history and whether they have a history of compliance as well. So the assessment is actually quite far-ranging, and sponsors should be aware of this before entering into any application. And what's very interesting, I think, is that the sort of genuine vacancy requirement as well, the assessment that I've just discussed, it seems to sort of spill over here as well when you read the guidance. And this is, again, something that should be looked at. There are connotations and similarities between the two. And so hopefully if sponsors are aware of this from the outset, they will hopefully satisfy both. But in circumstances where you have provided relevant information, you've provided a decent, detailed description of the role, you would hopefully satisfy the requirement for the points as a job at the appropriate skill level and obtain the 20 points. Thereafter, meeting the English language requirements, pretty simple. B1 level, nothing really more I can really address on that. And then you are in top shape, I would say, to then see whether you can score the remaining 20 points in the tradable points section. And on that, it's actually where I will pass you over to my colleague, Nina.
Thank you very much, Shiraz. There was a lot to get through, and as we've said already, there is still more to get through, and so please bear with us. My role now is to go on to look at the tradable points that we'll be looking at to be able to get those final crucial 20 points that are required to meet the 70 points total for entry. Now, as Shiraz has already mentioned, this is quite complicated, unfortunately. So I'm going to try my best to break it down using the guidance that has been provided since the 1st of December. So please bear with me. And also, if you are not very comfortable with maths, look away now, because there's a lot to get there in terms of equations. And I honestly feel for the caseworkers who will be doing this, because they will have to be quite on top of it when it comes to figuring out the main element of the tradable points, which is indeed the salary. So if you look at the table that's been provided here, we're looking inside the pink rectangle at the salary. This is where the sort of tradable points flexibility comes in. And there is a lot to try and digest and figure out when you are addressing the main element of finding these 20 points somewhere in the application. So if we look at the second bullet point here, in assessing salaries, sponsors must pay applicants either the relevant general threshold salary or the going rate, which is subject to permitted reductions, at whichever is higher. So this is the first element to look at. There are two technical salaries, the general threshold salary or the going rate, which need to be considered. And these can both kind of move around depending on the circumstances. Firstly, looking at the general threshold. Now, this is the minimum salary which applies regardless of the applicant's SOC code. So it doesn't matter what the SOC code is. If you look in the table for the skilled occupations, this is sort of the minimum that has to be met. Now, technically, the threshold sits around 25,600, but it can go down to 20,480, depending on the circumstances. Just to mention as well that it doesn't matter how many hours a week the individual is working in terms of how many they're sponsored to work, how many hours are sponsored to work on their certificate of sponsorship, and that this cannot be prorated for part-time work. So this is something important to say. it doesn't change for part-time work. You need to think of it in terms of the hours that are provided. So in terms of the hours that are actually considered, if someone is working a very high number of hours, you will actually only consider up to the first 48 hours a week. This is sort of the maximum in terms of how many hours a week the applicant will be working, even if they're working more. For example, if an applicant is sponsored to work 60 hours for £10 an hour, so a low salary, but a high number of hours, this would technically be annually £31,200, £10 an hour for 60 hours a week for 52 weeks. However, when you actually look at their general threshold calculation, because only 48 hours will be considered per week, this would be £10 an hour, 48 hours for 52 weeks, which would be only £24,960, which is below the general threshold of 25,600. So this is something to consider when you're thinking about general threshold. Next, the going rate. This is another way that the salary will be calculated, and it is the minimum salary which applies for a particular occupation code under the appendix skilled occupations. Now, this salary must be prorated based on weekly working hours, which is stated on the certificate of sponsorship. So this one is where a bit more maths comes into play. In terms of what caseworkers will be advised to do, they've been advised to prorate the going rate based on the annual figure rather than the hourly figure. In terms of the tables, you will see that the going rate is calculated based on a 39-hour work week. So you must divide the annual rate by 39 and then multiply the weekly hours that are stated on the certificate of sponsorship for the applicant. So for example, if it was if someone was getting paid £36,000 annually, this is the going rate, but the applicant is being sponsored for a 26-hour work week, you would divide the 36,000 annual salary by 39 hours a week, and then multiply this by the 26 hours that are actually being worked for a salary of 24,000 annually, which again is below the going rate. So this is all a bit complicated, I understand. I'm going to just show you a little bit more about this in terms of what I'm talking about in the tables. So you must check the salaries by referring to the appendix skilled occupation, which we've now been introduced to. Table 1 is all eligible occupation codes where going rates are based on the annual survey of hours and earnings, ASHD data. And the majority of the codes will be listed here. So when it comes to the caseworkers, they will be required to assess all tradable point options until they find one where the applicant can be awarded 20 points or all options have been exhausted and then the application falls for refusal. So it's quite a lot of pressure on the caseworkers themselves to make sure that they actually go through everything, but of course also for the sponsors and for the applicants to do their best to actually put in all the data and information to meet the requirements under Table 1 in the appendix skilled occupation. The other tables that are listed here, Table 2 is also significant as eligible health and education occupation codes. The going rates here are based on national pay scales. Now this is a little bit different in terms of national pay scales, and also there is a different hourly rating here. So doctors would be 40 hours a week, and NHS, other workers for NHS would be required to have 37.5 hours a week. Full-time teachers would also be 37.5 hours, or you must actually ask the sponsors for the full-time equivalents for the national pay scale. So again, added complications for health and education occupation codes. 3 and 4 relate to Table 2, and Table 5 are occupation codes that are not eligible for the skilled worker or intercompany transfer route. So this is laid out very clearly in this table. Now, when I was talking about options, this is what I was referring to. So options are where the caseworker or the sponsor will be looking at matching the salary with another area to find the tradable points. So option A is the most basic one. This is just the salary. And if you have the salary, you meet it, it's done, you get the 20 points. Option B, C, D, E, and F are where things get a bit more complicated. If the salary is not reaching the going rate or the general threshold, then you would have to instead make sure that you have something else that matches with this. For example, a PhD qualification, a job in a shortage occupation, or the applicant is a new entrant, or they are listed in a health or education occupation to be able to meet the 20 points. I've just put this out here for you to be able to see where this actually matches with the appendix skilled worker rules. Before you start, again, you have to check the salary first. So you must take into what's been given as guidance by for the caseworkers is that they must take into account all available information and seek further information from the applicant and sponsor where appropriate. So as my colleague Shiraz has already mentioned, this is something that's very interesting, requesting further information. This is great, make sure that if maybe something is not quite clear, maybe they would fit in somewhere, and we don't have enough information, then they need to be contacted, sponsors and applicants need to be contacted to be able to try and find those points. For example, if it's unclear from the job description if the occupation falls under the shortage occupation list, then they should seek further information from the sponsor. Now, unfortunately, just after this guidance, it also says that caseworkers do not need to actually make contact speculatively if there's nothing in the current application to indicate that an applicant may meet the requirements of a tradable points option, which goes completely against what has just been said, that they need to seek further information if something is unclear. So unfortunately, it goes a bit back and forth in this case. The guidance is not clear and is not very helpful in terms of requesting information or not requesting information. Looking at the eligibility points again, so I provided here a little worked example of assessing salary. Firstly, it should be noted that the basic gross pay is the only thing that will be guaranteed to be included. So other pay and benefits are noted in SW 14.2, and this is not an exhaustive list, so it's a little bit up to the discretion of the caseworker whether or not those will be included or not. The other thing to check is transitional arrangements. For Tier 2 general migrants, this is SW 14.5A. Again, this was something that Shiraz mentioned before. All listed conditions under 14.5A should be met before this can go ahead. So moving on to the actual calculations then. Calculating the going rate first. So the applicant's salary in this scenario is £28,000 annually, which includes £2,000 of allowances at 52 hours per week. The general thresholds, we'll look at this first. As mentioned before, only 48 hours for the week can be included. So you would take 26,000 annually, which is the 28,000 minus the 2,000 of allowances. They won't be included. Divided by the 52 hours per week times 48 hours per week, which would actually give you 24,000, and therefore the applicant does not meet the 25,600 general threshold of annual salary. But they could still score tradable points from the other options mentioned above, options B to F, which do include lower general thresholds, which start at £20,480. So next, looking at the going rate. As we mentioned already, the applicant's salary is £26,000 because allowances cannot be included. So here, we would then look at the occupation code for this applicant. In this case, based on the tables, it is £21,000 for a 39-hour work week. So because it's prorating under the going rate, all weekly hours must be included when you're prorating. Therefore, taking the £21,000 going rate for the 39-hour work week, you would take this amount and times it by 52 hours, which is what they're actually working, which equates £28,000, which is the salary that they should be earning per year. Unfortunately, because they're earning £26,000 a year, not including the allowances, this is actually less than the prorated salary. So again, they would fail to reach the going rate. You would then calculate actually the percentage of what they're earning or what they're getting paid of the going rate that is meant to be. So this is £26,000 divided by the £28,000 it should be, times 100, and the actual going rate they're being paid is 93%. Therefore, they cannot score points from any of the options which require the full going rate. However, they may be able to score points from other options, which include the 70%, 80%, or 90% of the going rate, because it is above the 90% at 93%. So, hope that's enough maths for all of you. Looking at this in terms of what a caseworker might need to do when they are looking at an application. So if the salary is at least $25,600, the general threshold, and the full prorated going rate is provided 100%, then this is option A. They get 20 points for the salary alone. There's no need to consider other tradable options. Easy, done. However, if this is not the case, then we have to look at the next level. And this goes on and it gets very complicated. And so when a sponsor is making their applications, they will have to look at these. They will have to review options B to F to see whether the going rate that can be calculated will fall under a lower percentage or the general threshold can be lowered. So for example, if they have at least £23,000 annual, and this is 90% of the prorated going rate provided in the tables. I do highly advise looking at table A. You'll see that there's lots of percentages there provided. Then you can look at options B and C for relevant PhDs, option D for shortage occupation, or option E for new entrants. And this applies as well for the 80% and for the 70% as well, but 70%, this should be noted, is only possible for option E, new entrants. If, however, the salary is less than the above and is not 70% or higher of the prorated going rate, then the applicant cannot score tradable points and must also be refused under option F due to the job not being in an eligible occupation. So, as we've said before, deciding whether they fall into any of these options, carry out a salary assessment. This is where, you know, accountants should probably get involved. Your math whiz, knowledgeable people should get involved to be able to figure out these percentages, these annual salaries, number of hours worked per week, etc. It all ties in. What also should be considered is transitional arrangements. So this is under SW 14.5b. Applicant can be awarded 20 points if all the conditions have been met under this section, and the date of application is before May 2023. This is something that Shiraz touched on before, so I highly recommend also looking at this because it will affect current Tier 2 general migrants who are in the system. Okay. Looking quickly at what options B to E are actually considering. Firstly, relevant PhD qualifications. So this is options B and C. You must check which are actually eligible occupations under Table 1. So when you look in Table 1, you'll be able to see whether or not it falls for relevant PhD qualifications or not. Occupation codes starting with 11, 21, 22, 23, 24, or 31 all fall under relevant PhD qualifications. If it's not under this, then it doesn't count, unfortunately. You also have to check that the qualifications are actually verified and genuine. This falls under, if it's been awarded by a UK institution, it'll be verified. If it falls from if it's been taken in an overseas institution, then it needs to be verified as genuine by UK NARIC, and how it will be equivalent to a UK PhD. Sponsors should also state their UK NARIC reference number on the application to be able to prove that it is genuine and verified. You also need to make sure that it's relevant for the job itself. And sponsors must supply credible explanation and refer to the job itself to be able to prove this in the application. Caseworkers have been advised that if they are unsure about this, that they need to talk to the case manager and also contact the sponsor or applicants to be able to make sure that the information that has been provided is relevant and clear. STEM qualifications are a little bit special. So this is science, technology, and maths qualifications. And these ones will give you 20 points, whereas other PhDs will only give you 10. And again, these need to be considered with the information that's provided, make sure that it's relevant to the job, and discuss with case managers or contact the sponsor or applicant if things are unclear. Shortage occupations is now under another appendix of the shortage occupation list. So some of the jobs on this list are only qualify if they meet either or 1 and 2, which is additional criteria and or jobs based in a particular UK nation or nations. So this is again very important to check. It can get complicated. The certificate of sponsorship should confirm, if it's on the list, what other criteria should have been met and what have been met. And the Home Office should contact the sponsor if things are unclear and request further information. The thing that has changed in shortage occupation is that, unlike the Tier 2 general, there is no minimum number of weekly hours that have to be worked in the shortage occupation, as long as the relevant general salary threshold and prorated going rate requirements are met. So again, go back to the assessment of the salary. This is very important to be able to be very clear on these things. Shortage occupation list shortage occupation list jobs applications are also lower. So therefore, the sponsor would actually have to pay a lower rate. However, if the application fails to score the points under the shortage occupation list, they must be contacted to pay a top-up. So if the applicant has paid a lower fee but can't meet the points for the job in this, once they've actually had their case assessed, the applicant should or sponsor should be advised that they cannot meet these points for the job, and if they wish to be considered under other tradable point routes, they will need to pay the top-up fee to the non-shortage normal skilled worker fee. If they do not pay this fee, then the application will not be considered under any other routes, and the caseworker themselves will not be told to try and change things to make sure that it fits the system or fits the general route. Conversely, if an applicant has paid a higher fee, but they could score points for a job in a shortage occupation list, then they can be contacted by the caseworker and can arrange for the fee difference to be refunded. Another thing to note, that if a job has been removed from the shortage occupation list, as happens, and as we know, this list seems to change quite a lot, but they were previously granted this under the Tier 2 general skilled worker route previously, then they can still award tradable points, but they must be continuing to work in the same job for the same sponsor. If they change their job position or they change their sponsor, then they would have to apply again. And if their job is no longer on the shortage occupation list, they cannot apply under the shortage occupation list route. Okay, so the final one, option E, that we're going to look at quickly is new entrants. These are individuals who are near the start of their career, who meet certain criteria, and it's not for first-time applicants for skilled workers. It's not that, or it's not their first time entering the UK. Please don't get confused with the terminology. It's really only for people who are about to start their career. So there's a couple of things that we need to look at here. There are again 6 options, and certain information will be required from the sponsor, so that they can consider the applicant if they're genuine under the new entrant criteria. I'll leave this table up for you to look at for now. And again, it's mainly looking at things in terms of their age, whether or not they were in a postdoctorate position, if they've already, if they're working towards recognized professional qualifications or chartered status, or if they're switching from tier 1 or from tier 4 to a career basically at this stage. And what they would need to provide to the Home Office is provided on the right side of the table. Just to mention as well that caseworkers should request relevant information for the sponsor and discuss with their case manager to be able to get this information and make sure that they're actually looking at the correct information before they just make a decision, really. What is also important to know about the new entrant route is that there's a 4-year time limit on the new entrant route. So they can only be new entrants for a maximum of 4 years. And this includes time spent in any tier 2 or skilled worker route, whether or not that permission was for a continuous period. If they're applying for more than 4 years, so if their skilled worker certificate is being granted for more than 4 years, this would mean that they would have a larger, they'd be outside the 4-year time limit in terms of permission, and therefore they cannot score the tradable points as a new entrant. So they would need to score points in another way. However, it must be noted that caseworkers who are reviewing this are not meant to grant them shorter permission just so that they would then be sponsored for a shorter period of time so that they meet the criteria. So sponsors need to be aware of this. If you are applying under this route and you ask for more than 4 years permission to be granted, your application will be refused. Therefore, you need to instead make sure that what you are granting falls within the 4-year time period. What you're asking for falls within this, as the applicant needs to be able to stay in the new entrant route only for a maximum of 4 years. Finally, just quickly, when it comes to the healthcare workers, this is a lower salary because it's going on the national pay scale. However, there is no discounts available. This is the lowest level you can go to, and they must be paid the full prorated going rate. The going rates here are a little bit different, so you need to consult Table 2 for health and education occupations. And make sure that you're aware as well of what the actual job is going to be within that area to match up with it. Now, the application fee for under this route is a little bit cheaper. So both for the in-country and overseas applications. So again, make sure that it matches the SOC code in Table 2, and the application fee will then therefore fall, and the actual minimum salary and prorated going rate will also be reduced. Okay, so the final thing we just wanted to discuss quickly is that there are quite a few current issues, as we can see. This is something that has been addressed by many legal practitioners, and recently we had the chance to speak to the head of UKVI, Work Study Family and Citizenship, George Shirley. And a lot of questions were put to him, to be honest, which I think is good because it really just makes sure that someone who is at the head of this new system, these new routes that are opening up, is aware that there are things that are missing in the system already that need to be addressed sooner rather than later. So some of the things that we put to him was how to prove genuine vacancy without the resident labor market test that's now been removed. Other things we asked were about EEA nationals' right to work checks, because at the moment, EEA nationals who arrive to the UK before the 30th of December will not need to have proof of their right to work. Employers can rely on their passports or residence cards until the 1st of July 2021. But again, what happens if something goes wrong in this time? How can employers protect themselves? There's other elements of transitional arrangements, especially for the certificate of sponsorship. There has been information provided that the certificate of sponsorship needs to be upgraded, and it's been provided in the guidance what upgrading is, but it doesn't tell you how and where to do this. So that's something that we feel is quite important that we don't actually have information on. As we've also talked about before, accepting digital documents and evidence. This is something that's sort of been brought in because of COVID, but if it continues on in the future, how will this be verified? There's also been talk of the defined costs, which is coming in, which has now come in, having a same working day guarantee. So you can pay to have this process expedited, to have it granted in the same working day. But it seems unlikely the Home Office will be able to process applications within 24 hours. So again, we need more information on how this will be rolled out and what sort of things they'll be looking for. The priority service as well for work and study, there has been talk of this being reintroduced, but we again don't know when this will go online and how it'll be available for applicants and sponsors. And we have now come to the end of our webinar. However, I can see that we have a lot of questions, but I'm going to pass over to Shiraz just to explain our thought process for this, if that's okay.
Right, thank you very much, Nina. And I'm sure everyone will now see just how difficult it is to try and meet these requirements, especially when you're trying to get those tradable points. But again, I'd reinforce the point, please make sure that all applications are considered fully and properly, because this is a minefield, unfortunately. But in terms of questions, I can see that, that Zainul has been studiously responding to many questions in the chat. Thank you very much, Zainul. But we've also received some questions prior to this webinar. So we thought we'd actually start by just discussing those. I can see that there are a few questions that are outstanding in the chat, but I think those questions, they really do require us to have a look at the rules, have a look at the guidance, and we're more than happy to revert back with our responses. And I can see that there's been numerous requests for the slides. We will make sure that a copy of the slides is sent out to everybody, and we will also be uploading this webinar recording to our YouTube channel, as well as, if possible, sending out a link to the recording as well. So don't worry about that. But in terms of the questions, I actually think that there's a few questions that we have that Nina might be able to address, because it's specifically with regards to matters that you have addressed, sorry. So Nina, I'll leave the first few questions to you, and there's two later questions that I can then address.
Thank you very much. Yes, so we have received quite a few questions already pre-webinar. And I'd just like to firstly say that actually, as we've said before, there is so much information, there's so much to get through. We already have plans to do a second webinar, actually it's our third webinar on this topic to address the sponsorship guidance specifically. And we will cover in more detail questions that you might have on sponsorship guidance in terms of applying, in terms of renewing, in terms of duties for the sponsorship license, which we will come to later. Firstly, however, the first question we had that I'm going to just talk about quickly is, can current intra-company transfer migrants switch the skilled route immediately for the same job but with a lower salary with the same employer, provided the salary is above the going rate? So we didn't really deal with ICT migrants this time, but we will in future sessions. The current guidance says, yes, this is possible, because, which is quite interesting actually, and is different from what was available under Tier 2. But yes, as long as everything is met in terms of the going rate and the general threshold, technically an ICT migrant could switch into the skilled worker route on a lower salary, yes. So a couple other questions that we had were based on Tier 4 students. We haven't, again, really talked about Tier 4 students. So again, we will be looking at this in another webinar. If you do have questions about that, feel free to send them through and we will have a look at the guidance, see what we can find. Another question we had was about restricted and unrestricted costs. This is something that has changed now. So this is different. Restricted and unrestricted costs have now disappeared, they've been removed, and they've been replaced by defined and undefined costs. So again, this is something that we will cover in our next webinar on sponsor guidance. And we are planning to have this webinar in January. We will send out more information on this if you are interested. Our prospective date at the moment is at the end of January. And I will pass on to Shiraz to answer the other questions.
Hi guys. So I've got two questions that were submitted, and I'll try to respond as best as I can. So someone's asked, if someone is currently holding a Tier 2 general visa, will they continue to work in that visa till it expires, or is there a mandatory requirement for them to obtain skilled worker visa? Well, it's totally fine for them to continue to stay here. There's no mandatory requirement at present, unless the guidance or the rules are updated. I would say that if you look at the definition of skilled worker, it actually includes somebody who has been here prior to the 1st of December 2020 as a Tier 2 general migrant. So technically speaking, you should be absolutely fine. However, when you make an application for either an extension of leave or indefinite leave to remain, those applications will be considered under the skilled worker route and the applicable rules depending on whichever route you're going down, whether it be ILR or an extension. The second question we have is, if someone is eligible for ILR in 2021, can they switch to a skilled worker visa to extend their stay instead of applying for ILR? I mean, there's a lot going on there, but on principle, yes, as long as, so you can switch as long as you're coming in from a permitted route. So if you're on a short-term route, or if you're here or with leave outside the rules, for example, then the skilled worker route's not just open, it's just not open to you. However, if you're here as a Tier 2 general migrant or any of the others, then yes, you should be totally fine in terms of switching into the skilled worker route and subsequently applying for indefinite leave to remain on whatever sort of grounds you're looking to apply for indefinite leave to remain. It might be long residence, perhaps, you're looking to just bridge the gap. But yes, in principle, it's possible, but again, it really does depend. Those are all of the questions that we had submitted prior to the webinar. Again, those that have been submitted in the chat, I think there's some outstanding. We'll be happy to get back to you individually. And also, as I say, a copy of the slides is available to anybody. We'll try and get these sent out as soon as possible. But thank you very much.
Thanks, Shiraz. And before everybody leaves, if I could just do a plug for our upcoming webinar in 2 weeks' time. I think it's on the 17th of December, and it covers recent developments in deportation law. It's been a fabulous year as far as lawyers for deportees are concerned, because there have been, I think, at least 3 or 4 very positive judgments relating to how the rights of children are taken into account when assessing whether deportation is consistent with Article 8 of the European Convention on Human Rights. So we're doing a webinar that is dedicated just to those cases, including a very recent case from the European Court of Human Rights. That's on the 17th of December at 4 p.m. Please do register and join us. Thank you very much, everybody, for attending, and we hope this has been useful for you.